Hello, good day everyone. My name is Tarindu Rangarangajiya and today I will presenting a comparative analysis of state role in employment relationship between Canada and Australia. This presentation will highlight how government policies, regulations and interventions shape employment relations in these two countries. Employment relations describe the system that govern the relationship between employees, employers, and the state. The state plays a crucial role by uh, enacting laws, regulation, wages, and resolving disputes. This presentation focuses on comparing Canada and Australia. These two countries differ in legal framework, economic context, and union influence, which make this comparison essentially meaningful. I will cover five key areas that are historical context, legislative framework, determination, union influence, and current influence like precarious work and gig economy. To begin, let's look at the high level of overview. In Canada, employment relations are primarily decentralized. This means provinces have the power to set labor laws, and the federal government only oversees about 6% of the workforce, mainly in national industries like interprovincial transport. In Australia, on the other hand, has historical had centralized system, but this has been shifting toward decentralization. Essentially, after the introduction of the Fair Work Act in 2009, this act plays a significant role in wage setting in dispute resolution. Historically, Canada's employment relations system developed under the influence of British and French legal traditions. A significant milestone was the introduction of the Charter of Rights and Freedom in 1982, which guarantees collective bargaining rights. In Australia, the Conciliation and Arbitration Act of 1904 centralized wage setting and dispute resolution. Uh, the work chooses reform in 2005 began to the shift power towards individual employment contracts and away from unions. This trend continued with the Fair Work Act in 2009, which now governs most aspects of employment relations. Next, let's examine the key legislative frameworks. In the Canada, province labor laws dominated. However, the Supreme Court rulings in 2007 and 2015 were pivotal in affirming collective bargaining and constitutional rights under the Charter. Meanwhile, Australia's Fair Work Act 2009 is concentrate of labor law today. It introduced 10 national employment standards or NES, which provide minimum employment conditions such as paid leave and maximum working hours. It also formalized enterprise bargaining agreement, a key method of negotiating wages and conditions at the workplace level. Wage determination is handled differently in each country. In Canada, minimum wages are set by individual provinces, and collective bargaining at the enterprise level plays a significant role, particularly for unionized workers. In Australia, the Fair Work Commission set the national minimum wage, which applies across all states. Enterprise agreements in Australia must pass what's called the better of overall test or boot to ensure workers are better off compared to the industry's minimum standards. Union influence has also involved in both countries. In Canada, unions play a prominent role, particularly in the public sector, where union density is significantly higher. However, the rise of non-standard forms of employment like temporary and part-time work has contributed to a decline in union membership. In Australia, union density has dropped sharply, particularly after the work choices reform. Although unions continue to exist, their influence has been reduced, especially when it comes to wage setting in industrial dispute. The way labor disputes are handled also varies. In Canada, province manage dispute resolution, which is with a strong focus on mediation and conciliation. Arbitrary is a rare, except in cases involving public sector dispute or essential services. In Australia, the Fair Work Commission plays a central role of dispute resolution. Strikes are statically regulated and are only allowed during enterprises bargaining negotiations, and the Commission can intervene if a negotiation breaks down. The state plays a significant role in public sector employment in both countries. In Canada, provincial government are major employers, and public sector unions have considerable bargaining power. However, wage restraints are sometimes imposed by the state. In the Australia, the federal government is a major employer, and public sector disputes are typically resolved through the Fair Work Commission, which ensure consistently across federal and state employers. Both countries are facing challenges with precarious work and the rise of the gig economy. In Canada, gig workers are usually classified as independent contractors, which excludes them from benefits such as healthcare and pension contribution. This is similarly in Australia, where gig workers work accounts for around 7% of workforce. However, the government has been slow to regulate gig work, leading the concern about wage shift, theft, and unfair working conditions, particularly in industries like delivery services and ride sharing. The gender pay gap is another issue affecting employment relations. In Canada, women generally earn less than men, although the gap tends to be narrow in unionized sectors. The equality laws existing by vary by province, leading to in, inconsistent progress. In Australia, the gender pay gap was around 14% in 2019. Women are overrepresented in low-paid and precarious jobs, and while the Fair Work Commission has taken steps to address this, the gap persists across many industries, particularly in sectors like healthcare and education. The gig economy is having a profound impact on employment relations in both countries. In Canada, gig workers are largely executed from traditional labor protections such as minimum wage and collective bargaining. In Australia, public pressures is mounting for the government to regulate the gig economy, but the process has been slow. Both countries facing significant challenges in adapting their labor laws to cover gig workers who often work to insecure and poorly paid conditions. To summarize, Canada and Australia have taken different approaches to employment relations. Canada's system is highly decentralized, with provinces taking the lead in setting labor laws, while the federal government plays a smaller role. Collective bargaining and union power are stronger, particularly in public sector. In constant, Australia's system, through historically centralized, involving towards a more decentralized approach. The Fair Work Commission remains a powerful regulatory body, especially in the wage setting and dispute resolution. Both countries are grappling with challenges like gig economy, precarious work, and gender play inequality. In conclusion, while Canada and Australia share common goals in protecting workers' right and ensuring fair employment conditions, their approaches to achieving these goals differ significantly. Canada's decentralized system allows the regional flexibility, while Australia's centralized system has been gradually shifting towards enterprise-based wage setting. Both countries face emerging challenges, including the rise of precarious work and the gig economy, which will be a require country continued adoption for labor laws and state policies in the coming years. Thank you for your attention, and I'm now happy to take any questions you may have regarding the comparison of these states' role employment relationship between Canada and Australia. Thank you.